In the last weeks of her life, Mica Frances Miller contacted police at least 15 times for assistance as she tried to leave her estranged husband. She reported instances of stalking, harassment, property damage, tracking, and domestic violence. She presented evidence and told the authorities that John Paul Miller, the pastor and founder of the now shuttered Solid Rock Church in Myrtle Beach, tried to throat punch her, that he had his hands around her throat. Specifically, she said this happened just before she was involuntarily committed. The incident caused her to have a panic attack, which may have been a catalyst leading to her hospitalization. The many police reports did not result in any consequences from law enforcement for the husband she was trying to escape. The public, and in particular those who have never been involved in a domestic violence call to police, frequently express disbelief and concern over the handling of these situations by law enforcement. Mica's situation was generally marked by inaction on the part of officers who either failed to investigate or who, one way or another, exhibited bias in favor of her pastor husband. As a result, John Paul did not face any consequences from law enforcement. Her life came to an end on April the 27th, 2024. Her body was found at Lumber River State Park. The Robeson County Sheriff's Office investigated and came to the conclusion that her death was self-inflicted. Even so, the agency asked the FBI to investigate. And despite their conclusion, throngs of people following this case believe her husband is responsible for her demise, either directly or indirectly. And in the aftermath, we've learned that Mica is not alone. Many other victims of domestic violence have come forward with similar accounts about the disappointing responses to their calls for help. By sharing their individual stories, collectively they're telling the story of an agency they say routinely fails victims by giving their abusers a pass. Because while the circumstances, damages, and personal toll differs greatly from one victim to another, their interactions with the Horry County Police Department are very similar. I'm Callie Lyons with FITSNews, and today I'm joined by Jen Wood, FITSNews assignment editor, and Brian Bennett, a retired member of law enforcement in South Carolina, who was the domestic violence specialist at the police academy. Thank you both for joining me for this important conversation.
Thank you.
Today, we're going to focus on the law enforcement response to Mica's pleas for help. For the record, FITSNews asked the Horry County Police Department to address these concerns, but we were referred to the department's domestic violence policy. We have asked for an opportunity to interview the chief of police, but so far we've received no response. So we're asking Brian to help us understand what has happened here and what might have been handled differently, both on the part of law enforcement and also on the part of the victims.
So the 911 calls that we have received, just a reminder, they are all found on the FITSNews YouTube channel. You can go to YouTube and look up FITSNews or FITSTube. It should pull it up. But within the past few weeks, we, as a response to multiple FOIA requests, we received longer versions of the calls and additional reports that were not included in the returns from our initial FOIAs. In some instances, we've found that these seem to give us some important details, and some of those details have put the interactions in a different light. It's been through the careful review and comparison of those 911 calls, the computer-aided dispatch reports, and the police reports that we're able to get a fuller picture of each of these incidents. And it does seem like a major sticking point in a lot of these police reports and these interactions that Mica Miller and John Paul Miller had with police centered around whether or not the incident was deemed to be a civil matter or a criminal matter. For example, John Paul took Mica's car and a number of her personal possessions while she was hospitalized. But because they were still married, the police dismissed her reports and called it a civil matter. So, what does that mean?
Well, it has a foot in both areas of criminal and civil. Now, as relates to civil, the fact that Micah and JP were married means that the property that they had separately when they got married became joint marital property. And what that means is that both parties have equal rights and equal share of control and interest in real property, which we would call like tangible objects. But it also means that finances and money are controlled equally as well. And it's not uncommon in controlling relationships that one party, the one that wants to control, will hide or limit access to important documents or property or monies or anything that someone may need, particularly the other party that may be in need of those things. And so, in this sense, if someone had a legal standing to control or own something, they are not to they're not to be considered to have stolen anything. You can't steal your own property. And again, it's because of that marital relationship that the things that that they had individually were considered now joint marital property, and the things that they obtained as a married couple were also marital property. And so, as far as the the taking of the cars and cell phones and things of that nature, and we'll get into some other issues a little bit later, that is why sometimes the terminology, well, this is a civil matter, there's nothing we can do about it. Well, that's not necessarily true. It is true to a large degree, but we also have to consider what is being done in the entirety or in the historical context of that situation. Again, in a domestic violence or a controlling relationship, mismanagement and control of those items and those necessities can be a very, very powerful tool to subjugate someone to all kind of forms of abuse by not allowing them the proper resources. And so, another thing I want to address with this is one thing that could alleviate this marital joint property is the issuance of an order of protection. I know there's probably some questions y'all have a little bit later, and we'll get in more detail. But to cover it right now, an order of protection through a family court is an opportunity for there to be a temporary division of marital property. The family court order of protection is quite lengthy. It's many, many pages long, and it's primarily due to the division of property or the court establishing who is going to control what and when. But that only lasts for the term of the order of protection. But that would have created a division that perhaps, if it existed, things more may have more quickly fallen over into the criminal realm and not kind of hovered there in the civil process kind of wasteland for a while.
That's very interesting and something I really had never considered before because typically when I think of a protection order, it's a response to violence. And it's kind of like a judge saying, you stay away, keep your distance from that person. So this is another side of it. Um, and, we know that Micah was denied a protection order. So even that route was closed off to her. It, that's very interesting aspect of it, though, to consider. A number of the calls that she made involve stalking and harassment. And specifically, 5 of those calls were about tracking devices that she found on either her vehicle or vehicles that belonged to other people that she was driving. And there was still a tracking device on the vehicle. Um, Now, is that criminal activity in and of itself, tracking someone with a device like that? And what determines whether that is criminal or not?
Yeah, this is another very a difficult area for law enforcement to navigate sometimes, and so it definitely can be considered criminal. Um, again, as is often the case, concerns of individuals like Mica need to be viewed in a historical context. And I don't mean to sound like a broken record, but that is true. Uh, there is a known history between two parties that are involved in any type of controlling or domestic violence relationship. And sometimes those histories are only known to those two parties. Law enforcement is not aware, has not been made aware of the particular variations that occur in those relationships. And so it's not illegal to put a tracking device on your own car and monitor your own or jointly owned vehicle. And if you in a marital relationship bought that tracking device, the person who bought it and the other party in the house also has equal control of it. Stalking and harassment using electronic means is often referred to as cyber stalking. There's some more uh, definitions that delineate, online versus other forms of electronic. Um, but but again, stalking and harassment needs to be viewed in a historical context. Now, it's important as we go into this discussion here that uh, everyone understands what South Carolina law says about these issues. And specifically, state statute actually gives us pretty clear guidance on stalking and harassment. And the first thing it mentions in our statute is that there has to be a pattern. The term pattern is used and defined both in stalking statute and harassment statute. And so a pattern, which is entitled, it's a 16.3.1700, means two or more acts occurring over a period of time, however short, evidencing a continuity of purpose. Now that's a bunch of legal terms, and lawyers get a hold of that sort of thing. But what I want people to remember, it says two or more acts occurring over a period of time, however short. So when we look at pattern, and this is why historical context is important, what was the pattern and how many of these quote acts occurred and over what period of time? And I think as it relates to probably things that Micah had mentioned, some that may or may not have been documented, I think a pattern existed, a pattern that she knew existed, and to some degree other people knew existed and law enforcement existed. But what was the continuity or the evidence of the purpose of the pattern? That's the other part of that definition. And it seems to show very clearly that the pattern was one of causing her some form of fear or emotional distress. And I want everyone to kind of keep that terminology, fear and emotional distress, in the back of their mind for a moment. Another thing that our statute relates to is a definition of electronic contact. Now, the definition of electronic contact is very, very broad, because I believe that our legislature understood that just like technology has changed in the past, it will change in the future. So they left the electronic contact definition under harassment and stalking fairly broad to make adjustments for the advancements in technology. But in short, it's a electronic contact is any transfer of signs, signals, writings, images, data, intelligence, or information of any nature transmitted in whole or in part by any device, system, or mechanism, including wire, radio, computer, electromagnetic, photoelectric, and photo-optical systems. That is a very, very broad definition of electronic contact, but I think you can see just about anything we have now and what we may develop in the future would likely fall under that to hopefully address these type of issues in the future. So those are two kind of really important definitions: pattern and what is electronic contact. But then we also get into the issue of what exactly is harassment and how does that differentiate between stalking. Well, harassment is a pattern of intentional and substantial and unreasonable intrusion into a person's private life, um, and the targeted and that contact or that intrusion serves no legitimate purpose. Now, let me stop there for a minute. That's not the entirety of harassment in the first degree. But where we get a little bit of problem here is that an unreasonable intrusion into a person's private life that serves no legitimate purpose. I could probably see where there would be a discussion either among law enforcement officers or the solicitor's office that JP tracking his cars, but also her cars, again, joint marital property, is a legitimate concern of his. I could see them having that kind of legal argument. But when the tracking device is put on someone else's vehicle, I think that's where we have a problem. A problem that can be more legally justified to look at an application of criminal charges. Tracking one's own jointly owned vehicle, it's going to be a hard one to make on harassment. But
So let's
tracking,
say this is like a nuance, like I'm a detail person. So let's say that, they separate
yeah,
and he keeps the car that they bought together and she goes out and buys her own car in her name. Um, is that considered joint marital property, or since she bought that after they separated?
it could be. I don't want
Okay.
to misspeak, but
Right.
unless there is an order of protection that has divided the property and given one person specific control of an item, or there's been a divorce decree, um, that is where things actually
Yeah.
separate.
Okay.
But just to be separated, more than likely, and in my experience, most family court judges are going to say, well, they're separated, they're not officially divorced, and there is no court document that has actually divided the property, so it probably would still be considered joint marital property, because it's not whose name is on the deed of the house, and it's not whose name is on the registration who's paying the insurance. Um, that can all be under one person's name, but the other party that is married, it's equally theirs still.
Right. Okay.
Um, and but again, the tracking device being on someone else's vehicle would cause me great concern, and it's definitely leading me into the area of looking at some criminal behavior. And the last part of the harassment definition says that this intrusion, this unreasonable and intentional and substantial intrusion, would cause the targeted person, and a reasonable person in that person's position to suffer mental or emotional distress. Well, I think very clearly Mica demonstrated that she was under at least some type of mental or emotional distress. I mean, everything that I've seen, and y'all actually have access to a lot more than I've seen, but I think just what I've seen, um, it worried her greatly. It worried her to a degree that she reached out to the powers that be, law enforcement and the courts, to try to find some resolution, to put that mental or emotional distress at some ease and have some peace or protection. And that what I just mentioned was harassment in the first degree. Harassment in the second degree is exactly the same thing, but they added the language of electronic contact. That's why I said that definition of electronic contact is really important, because I don't know this to be sure, but people always used to ask me, they'd say, Brian, why did the legislature make a harassment first degree and second degree? And always my quick kickback to them was, I think in harassment first degree, they forgot to add electronic contact. So they added electronic contact to make the harassment second degree, to cover all those bases with the electronic transfer of data and that sort of thing. But otherwise, everything's exactly the same between harassment first and second degree. Now, that takes us into a definition of stalking. Now, there is no first or second degree stalking. Stalking is a felony right out of the gate. It has a lot of the same words: a pattern of verbal, written, or electronic conduct that serves no legitimate purpose, intended to cause and does cause a targeted person or a reasonable person to fear. Now, here's the basic difference between harassment and stalking. Harassment causes mental or emotional distress in a person. Stalking creates a reasonable person to fear. In other words, fear of their safety. And specifically, it's fear of death or a person in their family being killed, fear of assault, on themselves or another one of their family members, fear of bodily injury on themselves or a family member, fear of criminal sexual conduct on themselves or another family member, fear of kidnapping against themselves or another family member, and fear of damage to property of the targeted person or their family member. And so there's a pretty, you know, significant list of, you know, what that fear factor is and what can contribute or what concerns, fear concerns a victim has. And so to these interactions that Mica had with law enforcement, you know, one curiosity to me would be, you know, what discussion or what indication was there of fear of these six things that I mentioned versus uh, mental or emotional distress? And I think it would be fair to say that both of those things likely existed to her, especially towards the end. And I might be jumping ahead a little bit because I know we're going to be talking about, you know, how can officers better respond. But what I want people to understand about harassment and stalking is it's not the perception of the officer that matters. And what I mean by that is the officer that's there in their uniform, they have a level of physical protection, they have an awareness protection factor about themselves, they have resources that they can turn to provide or mitigate the fear to themselves or that mental or emotional distress. But an application of harassment and stalking laws, law enforcement and prosecution need to look at it through the lens of the person who is complaining and through the lens of the personal experiences of the complainant. The little scenario, if you will, that I used to teach officers is that let's say that a dozen roses get delivered to a house. Well, the neighbor may see the delivery driver drive up and see these dozen roses put on the front steps or on the hood of the car or even hand delivered to the neighbor. But the next door neighbor doesn't understand what those roses mean. They take it to mean, oh, well, you know, somebody loves somebody, somebody cares, somebody's thoughtful. But to the person experiencing the stalking or harassment, those flowers may have a completely different meaning. Those flowers can be coded language that today's the day you're going to die, or you didn't think I knew where you were, or you didn't think you knew where I could find you, but I have found you, and these flowers delivered to your residence or your work is a message to that effect. And so for the person not in the know, it seems innocent. And but for the person experiencing the harassment or stalking, that's why it's so critical for law enforcement officers to understand what is causing that mental or emotional distress, what is causing that person's fear of safety. And again, it all goes back into a historical context of understanding what has been happening up to this point and what effect those behaviors from that controlling person are having on that targeted victim.
Let me throw something at you there then, because these 5 tracking calls that were made, where Micah called the police because there were trackers on her vehicle, they all occurred between March the 11th and April the 15th. So we have 5 calls in 34 days.
Mhm.
What does that say to you?
Oh, that definitely tells me that she is well very very worried about what's occurring and why this tracking is taking place, and um, eh, that in the most basic sense is what I would be concerned about. Is if she felt that this was concerning and she felt worried about it, then as a law enforcement officer, I need to do the same, and that means I got to dig deeper. I can't just think about what's on the surface level. I have to think about what's going on behind the scenes that has created this frequency and this pattern. And again, specifically, what would she think or what would she feel based on that tracking? And uh, the details in that, which again we can get to in a little bit, the questioning, the details in that would definitely make it more clear as to what steps we needed to take. I would say that in all cases, when someone has a concern, they need to report it and have it documented on an official incident report. A lot of people in society think, well, they themselves may not even perceive that this is a crime. There's a lot of people out there who think, well, this is just the nature of the beast when I'm in a controlling relationship. There's really nothing wrong about it's a lot of times because people don't know what is not criminal versus what is criminal. So just by their own perhaps lack of knowledge of the law, they don't call law enforcement. When they do have indications that it perhaps is a violation of law, they feel, well, it's unnecessary, or this is overly burdensome for law enforcement officers. They've got other more important things to do than to worry about little old me. But the fact of the matter is, it is a law enforcement officer's job. No one should ever feel like they're overburdening a law enforcement officer when it comes to concerns of their safety and their mental or emotional distress when they're a target of harassment and stalking. And which means that when you call law enforcement, there needs to be a tracked official incident report of the concerns, whether they rise to a criminal charge or not. And that's another thing too. Just because you file an incident report doesn't necessarily mean anything has risen to a criminal level. Sometimes that incident report is just what it is. It's to document concerns because a lot of times law enforcement officers are not around when these things happen to see it for themselves. So almost across the board, just about every one of these type of calls, the law enforcement officer is taking someone else's experience and putting that into the incident report, and then examining the factors and evidence that's been discovered to see if we have a violation of law. I took many law enforcement reports from complainants who were just like, I just want to tell you what's going on, and I want a record of it in case this can be used later. And sometimes that's what a law enforcement incident report is going to do. It's simply going to document concerns, but sometimes not fully known what those concerns relate to until further on down the road. But I would definitely hope that in every instance that she called law enforcement, I would hope that there was an incident report where uh, her concerns were at least documented and documented in detail, and perhaps a situation, or not situation, but a question we can, I think, address later that y'all wanted to talk about was, what type of evidence would be collected? What would officers do with it? How do they, help targeted victims collect this type of evidence to make these cases stronger? I can address that a little bit later. Or I can address it now. Whatever y'all want to do.
Well,
One
let's do
question I
talk.
had, yeah, I do want to get to that, but one question I had, like, as a law enforcement officer, when you're responding to calls like this, what knowledge do you have going into the call? Do you typically know if this is like, if this is a call that has happened before, if there have been, domestic violence reports, if there have been reports made, if there have been a history of these types of reports, do you have that going in?
Many times, yes, but although it can be very, very limited. Of course, y'all are both familiar with the CAD reports, computer automated dispatch. Anytime a law enforcement officer is dispatched to a call comes into the call center either on 911 emergency or the non-emergency line, and the dispatcher uses a computer program to assign officers to respond to the call. And as a matter of policy and procedure, the dispatchers are tasked with collecting as much information as they possibly can to provide the officers en route. Now, the availability of that information to the dispatchers greatly depends on the caller's willingness to give information or their ability to give information. Uh, some callers will only speak very briefly. because they don't want to say too much for many different reasons. But the dispatcher is trained to ask a series of questions. There's a checklist that most of them go through that are very methodical, and they ask the question and then they wait for a response. If they're confused, the dispatcher asks for clarity. But again, a person may not want to share with the dispatcher all the information because the dispatcher is not the one responding to the scene. They know that a law enforcement officer is going to, and the law enforcement officer is going to have more power and authority to do something. So sometimes they save that detail for the officers when they get there. And then in other instances, the victim may be under or the targeted person or victim survivor may be under some type of duress, either directly, indirectly, at the moment, or in the future, where they're not going to say anything anyway because their fear of retaliation and reprisal. So the dispatcher will type in to the call log, the dispatch records, any information about that they know about past history, availability of weapons, names and date of birth, perhaps that the law enforcement officers can go ahead and start running people's backgrounds through a criminal records check, or looking for orders of protection or restraining orders. Obviously, if the dispatcher hears anything troubling, like hears someone talking in the background, they may not hear exactly what's said, but they know that there's another person there. All these little things are put in that call card. And if there have been prior calls or dispatches to that incident location or with that individual, that call history can be brought up and made available to the officers either through dispatch or the officer's in-car computer. And sometimes the officers will pull that up themselves. And also, if there has been an official incident report, the dispatcher and the law enforcement officer also have the ability to pull up those past law enforcement incident reports and review them to some degree before they get on scene. Obviously, if it's an emergency, there may not be time for that. But if they have some time to review the prior incident reports, they may now have an idea, particularly in this case, if, well, we've already been there 4 times before. 2 times there was no report taken, but 2 times there were reports taken, and these reports indicate that there was, some harassment or some stalking. Well, that new officer should start thinking, well, maybe I'm meeting that pattern. Maybe that pattern's starting to develop itself right now. Maybe we're getting into the area where there is going to be a violation of criminal law in some degree. So a long answer to a short question. Law enforcement officers and dispatchers generally try to dig and find as much information as they possibly can before they arrive on the scene.
Okay.
And yeah, with the trackers specifically, she did
Mm-hmm.
try to turn them over as evidence.
Mm-hmm.
But instead of, each subsequent call being seen as an escalation and perhaps treated more seriously, we didn't really
Mm-hmm.
see that at all. In fact, in one of the last calls, the officer refuses to take the tracker, tells her to keep it, and
Mm-hmm.
tells her it's marital property.
Yeah. Yeah, and going back to what I said, because of that marital connection between the two. I mean, the officer's not wrong in what he or she is saying. It is, in fact, a marital property. And with Mica being part owner of that device, I mean, she may not have bought it, but if JP bought it, she Mica did have an ownership of it. Um, and what this means is that if she wanted to, she could have destroyed it. She could have canceled the tracking device service, and she could have even accessed all the data that was collected by that tracking device. But this is where it's problematic. Um, you know, was there a criminal complaint filed via an official incident report? And what, if anything, did Mica want to pursue? Sometimes law enforcement officers are going to ask, okay, well, do you want us to do an incident report? The answer may be yes. And then the next question they may say is, well, do you want us to pursue any criminal charges? And sometimes people say, well, I do want to file a criminal complaint, but I don't want any criminal investigation to take place. I just want to let you know what's going on. If she filed a criminal complaint, again, y'all know this better than me. If she filed a criminal complaint to be investigated and wanted to pursue any applicable charges, then at that time, the tracking device, the data it contains, the data contained in any app or programs that had that data, and that data contained on any other device is then now considered criminal evidence, because there's official incident report and there's someone wanting to pursue criminal charges. And so the legal access to evidence for forensic examination at that point is the responsibility of the law enforcement agency. Um, Plain and simple. When they now see that as evidence of criminal activity, it should be legally seized, and then the legal means and methods to access the data on there to see if there is actually a violation of law. Um, I don't know specifically if she expressed wanting to file criminal charges, but if she did not express that explicitly, um, in cases like that, unless there's a desire to seek criminal charges, it's highly unlikely that law enforcement would dedicate the resources, the investigative resources, and the time and effort to build a criminal case. This is a little bit different when you look at like an assault. Let's compare this to an assault, where someone is assaulted on a felony level, and maybe they're unconscious or don't have any ability to say one way or the other that they want to prosecute. Well, as long as there is sufficient evidence to support the assault, many law enforcement agencies will investigate and prosecute on the victim's behalf. But when it comes to stalking and harassment, um, it is often a consideration with law enforcement as to, does the complainant want us to pursue a criminal investigation, in particular to um, this electronic data. It's not impossible to get, but it is very time intensive and paperwork intensive and resource heavy to obtain all these things and collect all this data. And I would even say that even if all the paperwork could be filed immediately, getting all that data from the internet service providers and the companies that have that data could take weeks or months sometimes when the appropriate warrants or subpoenas are issued. So even if she wanted to do something immediately, realistically, it still could have taken weeks um, to obtain it, determine if there's criminal charges, and for criminal charges to actually be filed. It's very, very hard, but it's not impossible.
Interesting. There is no documentation that says anywhere that she told them not to pursue charges. Now, at the same time, I do not know that she knew to ask for that.
Correct.
And I don't know
Yeah.
who, I wouldn't know to ask for
I
that.
actually I was thinking that when you're saying that I think I know a lot about the legal process, but I don't know that I would have thought of saying, I would like to pursue criminal charges unless somebody
Mm,
approached me with that option.
mm.
Yeah,
Yeah.
yeah.
So one of the and we can go ahead and jump to it. One of y'all, we talked earlier, or communicated earlier. One of the questions y'all had for me was, is this a lapse in communication between the victim and the responding officer? It's a lapse in communication, but not to the targeted person or the victim, but it actually is a lapse on law enforcement not asking the right questions. Just like you said, I said I wouldn't have known what type of questions to ask. I would not have known what to tell law enforcement, and that's true. Most crime victims do not know what to ask. They often just tell their story and their version of events, what bothers them. But often those stories lack the necessary details for a full and complete understanding, and that is why it's the officer's job to stay away from. Well, back up. It's the officers or law enforcement's job to ask the right questions. You know, a lot of officers, not all, but a lot of officers, to try to quickly get to the facts of the matter. And some of them do it intentionally, some of them not intentionally. I mean, truly with good motives, but they ask very closed-ended leading questions. Um, and that is not a good way to respond to someone who's the potential victim of a crime, particularly one that is traumatic and has some level of mental or emotional distress and fear associated with it. Uh, the officers should be asking more open-ended, non-leading questions to get to the details that are needed in comparison to elements of the law. And when I was at the academy, that's something that I taught. I taught law enforcement officers how to ask the right questions to extract the information that is necessary to make an informed decision on how best to proceed. You know, victims of different type of crimes, they don't. People say, "Well, how does a victim act?" Well, uh, victims of crime respond in so many different ways. Some of them are very angry and upset about what has happened. Some of them are very indifferent and unfeeling and almost catatonic to some degree. Some of them are crying and distraught because they're so worried. But an officer has to be ready to encounter each one of those victims. And again, those victims are going to articulate things that they think are important, and many of those things are. But the officer also needs to think about what has been provided, but also what is missing. What am I missing to examine this incident as it relates to elements of the law? So that burden really falls on the officer. That's the officer's responsibility and the law enforcement agency's responsibility to be um, diligent, to be patient, and to ask the right form of question to get the clarity they need.
Yeah, I can see an opportunity here, because if the victim has a certain body of knowledge, if the victim is more educated in what they can say, what they can ask for, maybe we can all do better, if that makes sense. Not trying to place blame on victims at all, but
Mhm.
there's an opportunity there for education, I think. We keep hearing some of the same things from victims that have come forward to talk to us about their
Mhm.
own interactions with law enforcement. They're very similar. The
Yeah,
complaints
and
seem, yeah, go right ahead.
yeah, 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 no. So you're right. There some people have an aversion to dealing with law enforcement.
Yeah.
Some of those not wanting to deal with law enforcement comes from experiences that they might see on TV. They might
Hmm.
have a perception that law enforcement officers are overbearing and they're, um, to easily agitated and have attitudes, and they're like, well, I just, I don't want to deal with that type of personality. That's not who I need right now. Other people um, create a perception, and to many perceptions are reality, based on the experience that someone else had. Hey, let me tell you what happened to me when I called law enforcement. And then there's individuals who have actually called law enforcement hoping to get a resolution, or some type of finality to a situation, and that resolution or finality either wasn't available, wasn't offered, or their concerns were diminished and weren't taken seriously. And so um, those prior interactions with law enforcement can have a bearing on success in the future, or failure to that matter. And I as much as I know there's a lot of well-meaning officers out there who are in this job for the right reason. They want to be out there to help people. But just like any profession out there, I know that there are some who don't do their best, um, and don't live up to what they've been trained or taught. And some of that comes from uh, perhaps knowing all the information of what they've been taught at the academy, but then being exposed to more senior, more experienced officers who, in their own time, have become jaded, and they pass on that attitude of dismissiveness and not seeing people, victims, as being credible or taking them seriously, and that's passed on from a senior officer to a less senior experienced officer, and then that newer officer, may pick up that mantle as well. Um, and even well-meaning officers can get jaded at times. Now, that is never an excuse for a poor response to stalking, harassment, or domestic violence in any degree. But I want everyone out there to understand the reality of what a lot of officers face. I mean, a domestic violence type call is one that many law enforcement officers respond to multiple times a day, every day they're at work. And one thing that is very troubling and sometimes gets these officers jaded and perhaps expressing some type of attitude in their body or their voice or displeasure with the victim is when officers have intervened and offered the proper advisements and sought help from the victim survivor and saying, hey, are, do you want to prosecute this case? Are you willing to help me? Are you willing to help, show me some evidence? Are you willing to provide me a statement? And they've called police, but they're like, no, I don't want to pursue any charges. I just want to tell you what's going on. And sometimes officers are like, well, then what am I here for? Yeah, I thought you called me for help. And all I'm doing is, writing, what you're telling me on a piece of paper, but essentially it's not going anywhere. And then there's other times where, because maybe the police officers are there and the victim survivor feels a bit emboldened, in that law enforcement officers are there. There's a protective force right there who's not going to let anything happen to me right now, and they'll speak with more confidence. Yes, I do want to prosecute. I do. I will show you the things, on the injuries on my body. I will show you, the destroyed room. I will write you a statement. But then when the officers leave and that protective force isn't there anymore, there comes a sense of foreboding regret that, uh-oh, well, what are my resources now? Where am I going to go? Who am I going to turn to? Am I going to suffer retaliation or some type of, um, uh, admonishment? And it's a very severe way by expressing an interest to help law enforcement. And so they rescind, they take back that kind of cooperative attitude or that permission to help law enforcement officers. And I've been in that position. Now, it didn't affect how I responded to each and every call or even the same house multiple times. I responded to each one the same way as if it were the first time. But I can tell you that is a kick in the gut. That is a sickening feeling when an officer has reached out to help and doing everything they possibly can. It's that kind of you can lead a horse to water, but you can't make him drink. But doing all the right things, and the person you're trying to help almost turns their back on you. But again, I always had to tell officers, the reason it's not because that person hates you as an officer. It's not that they dislike you. It's because that victim survivor is worried about something more than you, the officer. They're worried about themselves. And so they're making those decisions out of a self-preservation. But you as an officer still need to do what is right to document, create that historical record that can either be used then or for incidents in the future to make those cases stronger. But it's a real kick in the gut sometimes. But many of your viewers are probably familiar, but for those that aren't, I mean, it takes a victim survivor, an average of 7 times to leave their abuser or their controlling partner before they make a final break. And often what causes that final break is something very, very, very severe. It is this buildup and this cycle of violence that continues to get worse and worse. And something finally happens where, there's this realization that I've got to get out or I'm going to lose my life. And I would say by the large majority, law enforcement officers never wanted to get to 7 times. We want to, help facilitate that the first time. But it doesn't always happen that way, even with the best of intentions from law enforcement and our prosecutors.
Right.
Sure. And I think also maybe it's important that victims have appropriate expectations. I,
Mm-hmm.
I think a lot of victims have the expectation that they would like for the responding officer to be a hero, to take their
Mm-hmm.
side. and that is not necessarily their role. Is
Mhm.
that correct? So what is the
Yeah, I mean,
appropriate expectation from an interaction like this? What is it reasonable to expect would come out of it?
yeah, well, what I would tell people to expect is you need to expect someone who is patiently going to listen to everything that you have to say, who would then help walk you through the other necessary information for them to um, generate an understanding or a decision. You should also expect a law enforcement officer to tell you legally what they can and can't do, based either on the lack of evidence or the availability of evidence. You should also expect a law enforcement officer with respect to harassment or stalking or domestic violence to be able to tell you what your rights and responsibilities are, that you yourself control, not the law enforcement officer, but you have power as well under the law to institute other actions and do things. I mean, we have something called Act 141, which is the South Carolina Crime Victim Bill of Rights, and that was established many, many years ago in our statutes. And in there is a listing of not just what victims should expect from law enforcement, but it also has a listing of what powers you have as a crime victims and certain things that you um, are expected to do as well. So it really has to be a joint operation. I mean, certainly in very severe circumstances, law enforcement officer and prosecutors can take the lead in many cases, prosecuting on behalf of the victim without their testimony, as long as there is sufficient evidence to do so. And there's uh, opinions written by the Attorney General and of South Carolina, and attorneys opinions written by the United States Supreme Court that say when there's sufficient enough evidence in domestic violence cases, that prosecution can proceed without the victim's testimony, as long as there's other sufficient evidence. But it really works best when both parties are working together. But I also have to say, law enforcement has to hear all sides of the story. Um, People should expect for their concerns to be heard. Um, they should expect, again, law enforcement to talk to all parties involved. They should expect law enforcement to investigate as best they can to determine, what truly occurred. It would not be fair for a law enforcement officer to only speak to one party and not speak to the other. I mean, certainly within our court system, we have something called due process. I mean, when we go into a court hearing, especially a criminal court hearing, a defendant has certain rights. Well, even though we're not in a court per se, we're on a scene investigating. It's important to hear from everyone involved, hear their perspective, and hear their information, and then investigate to see um, whose story and what evidence supports which story.
That makes sense. Just as there are best practices for law enforcement, I've been looking for best practices for victims,
Mhm.
how to handle these interactions, how to communicate in such a way that you have the best chance of success. And so some of
Right.
the things that I've been reading, I would just kind of like to get your comment on and see, if
Mhm.
this is accurate and, and valid. Um, of course, communication is key. Some of the guidance I read said, identify yourself, let officers know from the outset you're the victim, even if the abuser is trying to distort the information.
Mhm.
Be calm, which it's not going to
Mhm.
be easy to be calm under a
Yeah,
situation like this.
that's going to be really difficult.
Yeah,
Uh,
yeah, and try to be clear when you're describing the situation. Again, that's maybe a lot to ask of a victim, but being composed enough to clearly communicate what's going on, I can see where that would be important. Does
I
that
mean,
make a difference
yeah,
now?
certainly if a person's able to do that, I would say that that would be very helpful.
Right.
Um, but we also know in these situations the fear and the emotional distress can be so overwhelming to a person's psyche that they are absolutely unable to control the emotional state that they're in, whether it's aggression, whether it's unfeeling and kind of catatonic, or crying and distraught, because people handle stress in many different ways, and the responses that we see to stress are as different as the number of people that are on the planet. Um, but certainly, if someone could be more composed, because here's something we have to think about too, and many people may not be aware of this. When our brain is functioning, our brain can only do logic and emotion. It's very hard for our brain to do logic and emotion simultaneously. So what does that mean? What that means is that when people are under stress and they're emotionally charged to whatever degree, angry, all the way from angry to crying and distraught, and just curled up in a fetal position. When the brain is in an emotional state, it's not operating in a logical state. All right. Kind of to give you a comparison, one of the hot button topics you hear with law enforcement is de-escalation. De-escalation, de-escalation. Well, one of the tools of de-escalation to get someone down from the emotion that they're in is to ask them very direct, detail-oriented questions. The idea being is that if we can engage the logic side of someone's brain, the emotion side comes down, and as the logic builds, the emotional side comes down. But with respect to what you were saying about trying to be calm and composed from the victim perspective, well, when they're in that emotional state, they're not thinking clearly always. There can be gaps in memory, there can be gaps in understanding, and quite frankly, the autonomic systems, the psychiatric and psychological functions of our brain can kick into a safety mode where it actually represses traumatic memories. And then we also have the physiological responses to trauma, because our brains and our bodies have there's a connection there. When the body doesn't feel good, the psyche doesn't feel good. When the psyche doesn't feel good, the body doesn't feel good. And so these things kind of in a lot of ways operate autonomically, but there are means and methods out there with proper training, like what they call trauma-informed care or trauma-informed interviewing, where law enforcement officers and other behavioral science professionals and even medical professionals can try to move that needle of logic thought up while simultaneously bringing the emotional part of the brain down. And that's helpful. That's very helpful in trying to gain information and clarity.
Certainly. So if in the moment the victim finds they cannot communicate some of the important information, what would be an appropriate way for them to follow up to make sure that the information is communicated ultimately?
Yeah. So two things is I would still call law enforcement and ask for, and not to ask for, but demand an initial incident report to go ahead and kind of get things on paper, if you will. But I would also say, once some time has passed and once there has been created a safe environment, if that's possible, which is another thing law enforcement can help facilitate. Law enforcement officers can facilitate a more physically safe environment. Once that safer, more calm environment takes place, and there's some memory recall, I would tell individuals to start taking notes for themselves. When it comes up, jot some notes down, and then call law enforcement back. But I would also say a good practice, a good best practice with law enforcement officers is a follow up investigation or a follow up response to a previous call, just for the sole purpose, not just for the sole purpose, but for an additional purpose of, again, seeing if we can tap into another time where more clarity is involved. This is something that should be common for domestic violence calls, but it doesn't always happen, and sometimes that's just a matter of call volume and police officers that were on that call having 2 or 3 days off from work, and then coming back and then getting overwhelmed with another mass of calls. Um, and then again, this is why I was going back earlier talking about, the delegation of resources. Someone doesn't express, and again, this is not in all cases, not in all domestic violence cases, but with stalking and harassment, if someone doesn't express an interest to pursue criminal charges, um, there probably isn't going to be that delegation of resources or that follow up. You know, uh, someone says, "Hey, yeah, I do want to press charges. I do want to consider criminal charges." What I would say to that is, okay, well, we've gotten some stuff on the books now. I've gotten some, some of your information, some of your concerns. Um, you call us back. That was one thing I'd always say to law enforcement officers. Always feel free to call us back anytime, day or night, if you need us. If you need us for help, or you just want to tell us something, if you want us to update the incident report. But at the same time, I would also say, I'm gonna reach back out to you as well.
You want to, anything you want
Yeah,
to
no,
add?
I was just gonna say, in the past year, I've found that two-way communication
Mm-hmm.
between law enforcement and victims and families of victims, it just seems to make the world of difference between, a good outcome.
Mm-hmm.
So a lot of times, even if a law enforcement officer doesn't have anything to report back, checking back in and saying, hey, there isn't anything new in this. I just want to check in, see if there's anything new on your end.
Mm-hmm.
We're still pursuing things, we're still doing things, but just that knowing that their file hasn't, fallen to the bottom of a giant pile on somebody's desk is such a huge difference. And I think, a lot of people, and I think women especially tend to not want to bother people.
Mm-hmm.
I know that's like, oh, I don't want to bug that person. People
Right.
need it's like, I teach my kids, you need to learn to advocate for yourself.
True.
And you can do that. You can do that in a pleasant manner, and if you need to get pushier about it, you can do that. But it is okay to reach out and say, hey, listen, I haven't heard from you, I just need to know what the status of this is. And I just think that two-way communication makes a world of difference when
Yeah. and
working with
and and
people.
and when there is an actual criminal investigation that is taking place, the Act 141 Victim Bill of Rights says that a victim should be regularly informed as to the status of their case. Now, I also have to say that that can be limited to some degree, because depending on the criminal investigation, there may be things that law enforcement cannot tell the victim
Right.
to with respect to the investigation. But again, being informed that, hey, we're still working on it. We're still, that is something that they have a right to. And then you use the word advocate for oneself, but we always want to remind people we have a group of individuals called victim advocates in South Carolina. I'm not aware of any law enforcement agency that does not have a victim advocate. And victim advocates work for the law enforcement agency, whether it's city, county, state level. Many solicitors' offices have a victim services division. Um, some of those individuals are actually sworn law enforcement officers, some are civil service. But not the sole job, but one of the main jobs of the victim advocate is to do exactly that: advocate for the victim, to provide them information, to provide them resources, to provide them insight, understanding, to be kind of a liaison, if you will. That where the officer that responded, 2 or 3 days ago may not be directly available, the victim advocate may be available and should be available to the person who is the victim of crime. And I'm very happy that we have individuals that serve in that capacity. But I would also say there is a desperate need for victim advocates in the law enforcement profession. There's not nearly enough to deal with the caseload, and so it's not uncommon for a victim advocate at an agency to have 20, 30, 40 cases that they may be involved in.
Yeah, the whole
So,
process, I guess it's, in one sense, I didn't realize, just as a victim, just how overwhelming it can be. Because, you get through this criminal investigation process, you get through these, the steps calling the police, the steps of making these reports, the steps, to pursue, criminal, criminal charges. You get through all these steps, Then you move into the legal system, the court system.
Mhm.
And you know, that process, you know, you've got preliminary hearings, bond hearings, you know, trials, plea deals, sentencing, parole hearings. I mean, it's a lot. It's overwhelming and it's a lot to keep track of. So those advocates are they're such a huge component of the system that I think, you know, I do know that they work very hard. A lot of them are very understaffed, but
Mhm.
you know, they are such a great resource if you can get tapped into a good one.
What I wanted to say about that is, someone does not have to be criminally charged with anything to seek out a order of protection or restraining order. There doesn't have to be Someone doesn't have to be criminally charged. I mean, there's the plain and simple of it. And so let's talk a little bit about that, because I know that's come up with, I think, that she had maybe filed for an order of protection but was denied.
Mhm.
When it comes to orders of protection and restraining orders, let's talk about a couple different things: terminology and jurisdiction. There are two documents issued by the courts that limit a person's ability to interact with another person, and that is specifically an order of protection, which is an order from the family court when there's a relationship between two parties that meet the household member definition. Okay.
Mhm.
Now that has changed slightly. Not too long ago, there was a ruling by the South Carolina Supreme Court, which was backed up by a ruling by the United States Supreme Court, that said that persons who are in a same sex relationship but that don't meet the definition of a household member are still afforded the right to seek an order of protection through the family court in a same sex relationship. Now, South Carolina law hasn't made any adjustments to same sex relationships as far as the domestic definition of household member, but to let everybody know out there, same sex couples, although they may not be perhaps legally married, still have a right to seek an order of protection through the family court. Okay. And again, that terminology is an order of protection. Now, something I alluded to earlier is that the unique thing about family court orders of protection is that for the term of the order, which is usually a minimum of 6 months, it can be extended up to a year. A family court order of protection can divide marital property, and the court determines which party gets control of what items. And it also determines who's going to pay what bills and who's going to get, you know, whatever child custody arrangement. I mean, the family court order of protection is essentially a temporary divorce decree. I don't know. That's the simplest way for me to explain it, with a protective aspect to it that is limited in duration. You know, when you get a divorce, it's, you know, it's done, it's over, um, and that stuff's divided forever. But during a family court order of protection, it's only for the term of the order. Now, the other terminology is a restraining order. And a restraining order is generally heard not by the family court, although the family court can do it in an emergency, but restraining orders are generally heard by summary court magistrates for relationships that fall outside the household member. And essentially, anyone can seek a restraining order against anyone else, regardless of relationship. This is where you might see, well, you know, someone gets a restraining order against their neighbor. Their neighbor is bothering them, harassing them, and they get a restraining order against their neighbor. Or a customer gets a restraining order against a clerk at a store because the clerk bothers them when they're in there, or has followed them home, or something like that. And so the reason I'm saying this is because when we use the term protective order, and I want you to notice that the word protection comes before the word order. When we talk about a protective order, that is a umbrella term that means an order of protection or restraining order. There really is no document called a protective order in South Carolina. It's either an order of protection or a restraining order. Even to the degree that at bond hearings, you know, when someone is criminally charged and they have a bond hearing, the judge can institute a condition of bond that says one person has to stay away from the other. That's not a protective order. That is a condition of bond that includes a no contact provision. Now, I don't know if that makes sense. Am I making sense?
Yeah, no, that makes
Yeah.
perfect sense.
Okay.
Mhm.
And so when law enforcement officers hears from somebody, well, I have a protective order. I have a protective order. Well, we have to figure out what that means. Was that an order of protection issued through the family court, or are you talking about a restraining order, or are you talking about a condition of bond? Because it makes a difference on it makes a difference because those documents determine some limitations, and also how to enforce those documents, those orders, when they're violated. So, uh, so again, protective order is kind of a generic term to describe order protection, restraining order, or a condition of bond, no contact. Now, a few things came to mind when y'all asked me to consider why her petition might have been denied. And I really had to think a lot about this because I'm not a magistrate, I'm not a family court judge, but I've been in a lot of these hearings. I've been subpoenaed to a lot of these type of hearings. And it's important that people understand, unlike a criminal court where there needs to be proof beyond a reasonable doubt to convict someone, in the family court or magistrate court, when there is an order of protection sought or a restraining order sought, it's by preponderance of the evidence, not by reasonable doubt. Preponderance of evidence. And what that means is what argument presents the most weight to tilt the balance ever so slightly to one's favor over the other. I mean, it's like a 51% versus 49%. And judges who are in these hearings are the one that make that determination. So when Mica filed her petition, and that's how it starts. It's an actual petition. There's a document that a complainant fills out in the appropriate court saying, I am requesting a hearing because of these factors. The court first looks at that petition, they see what is contained in there, and then the court makes a determination whether there will actually be a hearing or not. So the first hurdle to get over is my petition good enough for the court to schedule an actual hearing? And if there is a hearing scheduled, due process says that the other party, in other words, the person who the order is being sought to go against, has a right to attend that hearing and give testimony as to why the order should not be placed on them. Now, there is some limited circumstances where an emergency hearing may take place. It's what we call an ex parte hearing. That means only one party is heard. The court can grant an ex parte emergency hearing, but the petition has to demonstrate an extreme risk of danger or death, and something to substantiate that things are that serious. So there are people that apply for an emergency order of protection or restraining order, but are like, no, the judge says this doesn't rise in my mind to an emergency issue, and either they say, there's not enough here for me to schedule the hearing, or I'm going to schedule the hearing but not an emergency. And so when she filed the petition, one thing that I think the judge may have considered was, what was marital property? What cars were marital property? What tracking devices were marital property? And what documentation or what evidence was there to demonstrate a pattern of behavior that caused Mica to experience either mental distress or fear, which is what an order of protection is supposed to be about, is that fear of safety. Now, Mica you don't need an attorney or a lawyer to fill out these petitions. So that's another a bit of misinformation that abusers like to put out there is, well, you don't have an attorney to go file for an order of protection and you don't have any money. Well, the law actually says you don't need an attorney and you don't need any money to fill out a petition. And the forms are so simplified, you don't need an attorney to fill it out. But one thing that I would say definitely helps with that petition is the existence of official law enforcement incident reports. Micah or anyone else could go in there, swear and affirm, give direct testimony. They could maybe provide a list of, cell phone records and text messages and emails that they have brought themselves. But it makes that request much, much stronger when the person has called law enforcement and gotten one of those official incident reports that I was talking about earlier. And in Micah's case, y'all had let me know about, or we've seen that there were some razor blades in her tires. In or around, I mean, was her tire slashed or razor blades in them? I didn't know specifically which
Razor blades. They were like tire deflating devices that you can.
Okay.
Yeah.
Okay. So the tire deflating devices, again, with respect to that, the judge would be looking at, okay, what evidence, if any, is substantiated that her husband was the one who put it there? Or could it have been her husband? Or could it have been someone else? And so that's another thing the judge was probably looking at is, well, I mean, you can put a tire deflation device under the wheel of your own car. I actually knew someone who actually did that. They live in a very high crime neighborhood in another state, and they bought one of these little tire deflation devices that if their car got stolen in the middle of the night and backed out of the driveway, the thief would, puncture the tire, and the car could be found, a mile down the road.
That's pretty smart, actually.
Yeah, I know, right? I mean, it's like would you want to put a steering wheel lock on your car? I think that would be an easier thing to do, but to be more sly about it, because and you can buy them. I mean, people can buy these things and put them around their own tire, and you wouldn't see it at night, and you probably wouldn't even see it during the day unless you were actually looking for them. And it's not against the law to destroy your own property. It's not against the law to destroy your own property or your marital property. What is against the law is to burn your house down. I mean, that's called arson. But destroying your own property is not illegal. So again, that marital property, joint property thing was probably a really big factor in that order of protection complaint. And since her petition was denied, again, if it wasn't denied, JP would have had a right to come to court and contest him receiving an order of protection against him. And depending on what he was able to say and what evidence he was able to present, I mean, I've seen order of protection hearings go to the favor of who was claimed to be the abuser or the controlling factor, and against the person who actually filed the petition. It's again who presents the most evidence, and so the decision by the judge would likely have been based on what, if any, documentation or evidence she was able to provide. But let me say this too, and this is Brian speaking without I'm retired law enforcement, so I guess I can probably say this where others can't. We have a huge problem in South Carolina with judges not following the definition of pattern that we see in the harassment and stalking law. You might say, well, what do you mean by that, Brian? Well, as you heard me say earlier, pattern is two or more acts occurring no matter how close together. Well, we have a lot of especially magistrate level judges, but I would probably say family court judges, who have made it known that to the law enforcement officers, don't tell people to come up in this court and file a petition unless y'all can give me 3 separate or 4 separate or 6 separate distinct and separate incident reports. And you're like, well, wait a minute. So when we look at like this, why is this problematic? Well, technically, a law enforcement officer, when they fill out an incident report, they can document multiple acts of a pattern on one incident report. Say, well, how was that? Well, because on an incident report in law enforcement, it has a beginning date and time and an ending date and time. Well, those dates can be minutes apart, days apart, weeks apart, months apart, years apart. So essentially, on the incident report, you're showing that there's a window of time. Well, if you've got uh, a, 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 a timeline that covers 5 days, but there's been 35 text messages and 25 telephone calls in that 5 days, that's way beyond a pattern. And that can all be documented on one incident report, but some judges say, no, I want a separate incident report for every one of those instances.
Right.
Well, and so what happens sometimes, and I've heard this from law enforcement officers all across South Carolina, is they're like, well, I look at some of my victims and I'm like, well, my judges only see the number of incident reports. They don't consider the number of acts. They consider one incident report to be one act. Well, now you're putting the law enforcement officer in a bad position, and you're putting the victim in a bad position. Now, to be fair, I've told the law enforcement officers, hey, look, if you know a judge requires 6 different incident reports, then count up all the acts that occurred over that 5-day period that month, and knock out 5 separate incident reports that categorize them separately, and help your victim when they go to the court. But we've got some judges out there deciding they're going to pick their own number. We got one incident report and it has 2 acts, but I want one incident report with at least 10 before I consider the seriousness of this issue. And another judge may say, well, I want separate incident reports. I don't need 2 separate incident reports. I want 5. And I've heard every kind of number you can think about from one end to the other across this state with some of our, mainly magistrate level judges, but I'm sure it's occurred in some of our family courts as well. And that puts the law enforcement officers in a bad position because they're looking at the elements of the law and what pattern says 2 or more acts, no matter how close together. But then they know that they need to, warn the victims who are needing help that, well, if you go to the judge with just this number and just what I did today, they're not even going to consider your petition. And I think that's problematic. That is
Right.
not in compliance with what the law says. That's a judge making their own decision about what they want coming through their court and when they're going to give it serious consideration. And just like we tell law enforcement officers, take every complaint seriously until you know otherwise. Well, I think the judges need to do the same. Take every complaint seriously, and unless you know otherwise, and to I understand that they don't want people coming there filing frivolous court documents, because I know there are people that do that, and to some degree they might be trying to mitigate that to not to keep the court or the judiciary from being used as a pawn in someone's control game. But at the same time, it's really hamstrung in a lot of ways our law enforcement officers and our victims out there who really need some help.
This is helping another piece of the puzzle come together for me because Jen, I'm sure you recall, she sent in FOIA requests trying to get incident
Yeah.
reports. And as we know, we've been in the process of requesting incident reports for 8 or 9 months now. We still don't have them all.
Yeah.
From what I understand, her request was denied. That could have played a significant role in what happened here and how this unfolded. So I just want to thank you, Brian. I've learned so much from this conversation. I think going back, the big takeaway in my head though is if you're the victim, don't wait for the police officer to ask you if you want to press charges. You let it be known that you want to press charges.
Yeah.
And
And I would also, because we're getting towards the end here, and I'd like to finish up with this, if I might. Statutorily, specifically, Title 16.3, 1810 says that officers shall notify complainants of the right to initiate criminal proceedings and how to seek a restraining order. So the burden is on law enforcement officers to tell people whether they ask for that or not. And with respect to filing for someone filing for a restraining order protection on their own behalf, law enforcement can't do that for victim survivors. The victim survivor has to file for an order protection restraining order on their own behalf. But under Title 16.3, 1820, there is a criminal and civil immunity to those who file orders of protection or restraining orders in good faith. And what that means is that if a person files a petition for an order of protection or restraining order and they're doing it in good faith, they're not falsifying information, they're not doing it to use the court to control or manipulate somebody, they're not, this isn't a retaliatory type thing. The person filing for that petition is immune from any criminal or civil penalties that someone may seek against them. Again, as long as what they're doing is in good faith. And there's an organization called South Carolina Legal, or SC Legal. They have a website in South Carolina. They also have a YouTube channel, and I would encourage a lot of people in these type of instances to go onto their website and go onto their YouTube channel. And these are attorneys who actually provide training videos to explain in more detail a little bit about what we talked about today, especially as it relates to filing for orders of protection, filing for restraining orders, what the hearings actually are designed to do, what the judges are looking for. It's a really, really great resource for people to see through an attorney, attorneys who specialize in these things, what they have to say.
Well, thank you so much for your time this evening. I really appreciate it. And you too, Jen. I
Thank
learned so
you.
much.
This is a great conversation. It answered a lot of questions I've had while covering this story.
Glad to offer any clarity. I would say that I'm obviously not been privy to all the documents that y'all have had. I'm really speaking from what I call a blind expert position, because I know some aspects of the case. And so I want people to understand that some of what I was expressing is in general terms, not necessarily specific to this case, although there's a little bit of overlap.
Definitely. And of course, our offer still stands. We would love for someone from the Horry County Police Department to sit down with, just like you are, in an interview situation, and let's talk about some of these things, and let's talk about how victims need to communicate, or whatever the issue might be there. But maybe we can all, including journalists, maybe we can all do a little better and avoid some of these unfortunate outcomes. So, well, thank you both. Of course, we are not done digging on the Mica Francis Miller case, right, Jen?
So, we
Far
got
from
a lot
done.
more work to do, but I do think we're getting somewhere with it, I think.
Yes, absolutely.
Yep.
You can find us at FITSNews.com. For FITSNews, I'm Callie Lyons.